contentious and transactional IP and technology law matters covering a variety of industries, and he's been featured as one of the 50 most influential people in IP 2021, which is, he's a big name. He also was featured in Forbes Legal Power List 2020 and 2021 as one of the top 100 lawyers in India. He serves as an expert member at the European Observatory on infringement of IP rights. It's a pleasure having you here, and we'd like to first welcome you before we begin your presentation. I request Malhotra ji once again to welcome him. Over to Mr. Ankit Sandhi.
Thank you so much, ma'am. It's always a pleasure to be back here in the midst of where all the action happens at EPC. Is really grateful once again for the opportunity to be at this fair and to be addressing everyone on this rather talked about but at times very controversial topic, which is intellectual property rights. So I have a presentation at that end. I'll try to squint and see because it's a bit far from here. But yes, I could probably, or maybe I could just stand and present. I'll be more comfortable. This is a painting from the Gond tribe, and it's a painting, a style of painting which has been protected as a geographical indication. Last time I unfortunately couldn't attend, but I believe there was a lot of focus on GI, as is the case both from the government side as well as the industry. EPCs did a fantastic session with some wonderful experts who had come and addressed us on GI. So a lot of products, I believe, which we are dealing in, which we are exporting out of India, are GI products. There is a lot of demand. So at some stage during the presentation, my attempt would be to touch upon this and to be able to talk about some of the legal nuances of GI, and to be able to maybe get some questions from your end as to how do we leverage or maximize the advantages of GI, how does it add value, and at the same time what are some of the safeguards that we need to take while looking at this thing. So with this painting and on this note, I come to my first slide. So as a brief overview, the idea is to, when you look at intellectual property, it's very similar to any other kind of property. It's very similar to a car or land or a house or any other kind of asset, movable or immovable, that you own. So under law it's treated as a movable intangible property, something you can't see naturally, which is why it's intangible. And movable because it can be transferred from one person to another. But in India broadly, even globally, the categories of intellectual property, they fall into these buckets only. So there's trademarks at the very top, brands. There's patents, which is of slightly less relevance to this audience, but it is a very important part because most of the things that we use around us, phones, laptops and other kind of technology, cars, etc., they all have a huge number of patents that kind of run the show behind the scenes. Then copyright, this does concern this industry, and we'll be looking at some of the copyright issues and where it overlaps with designs. Designs is the, I've also spoken in the past, about 3-4 years ago, we had a very extensive session on designs when we launched the EPCH in-house design register. So we'll try to touch upon some aspects that overlap, design law aspects that overlap with copyright law. Then there's of course confidential information, trade secrets, which in India is largely governed by contractual law. There isn't a statute, like an act that specifically allows somebody to register it and enforce it in court, but it's protected by court by virtue of a party entering into a non-disclosure or a confidentiality agreement with the other party, and then any breaches that arise out of it are actionable, of course. And then GI, we already started with that. So that is sort of the lay of the land. And to match with that, we have these corresponding legislations in India. As you can see, many of them are very old. So in India, IP is not something which came yesterday. India has enjoyed an IP regime even pre-independence. And some of these legislations go as far back as 1957, the current version of the Copyright Act as it stands. and Patents Act again 1970 and so on. So this is the body of law that we look at. India is also a member of several significant international treaties, so our protection systems therefore are at par with the protection systems in the European Union or in the US. So for any questions or doubts that we may have, India has already, many years ago, as far back as mid-90s, harmonized its IP systems, will brand recall, association in the minds of a consumer with a particular brand and the quality and the finesse associated with it. Therefore, slogans are also protected as trademarks under law. Then we come on to some unique kinds of trademarks which have come to be recognized in India and overseas as law developed, as business and innovation developed. So this, I'm sure most of us obviously know about, and we can recall and recognize this. The interesting thing is the shape of this bottle, in which it's not even the product itself, it's the container in which the product is contained. And many of us probably consume this at least once or several times a day. So this is the famous Coca-Cola bottle shape. So shapes or product shapes or three-dimensional objects are also allowed by law to be trademarked, so long as you can demonstrate that there is a section of the public, which is your target audience, that can associate a shape with your business and it can unequivocally be associated with your business. So then come some more forms of marks which have recently come, with the caveat that Indian position, Indian law as of the moment, of course there's been some amount of creativity that the courts have had, they've stepped in, because law always tries to play catch up. The courts, matters reach court and courts are more aware of what the business realities of the world are. But in India, so far as the position is concerned, trademark is defined under section 21ZB still as something which is capable of being represented graphically. So each of the previous categories of marks, obviously you can represent them graphically, which is why they are there on this presentation. But some unique kind of trademarks that have come to be recognized, protected, and as we move towards a more globalized world and more accepting, more innovative techniques and ways of marketing ourselves, we should bear these in mind. So the most common non-traditional mark which is registered now very frequently is a sound mark. So when you look at the MGM lion there, you can almost just by looking, the roar of the MGM lion would probably start playing, because all of us have seen a number of movies which start off with the MGM lion's roar. So that roar is registered as a trademark in India and many countries of the world, in fact. Same with Netflix, the animation and the sound when we open Netflix. So these are sound marks. And how the courts and how the trademark office in India now allows it to be registered, with the limitation that marks have to be represented graphically, is they make you submit the sort of the wave depiction of that. So the sine wave depiction of the sound is what you graphically submit along with the MP3 file, which contains the actual sound which you want to protect. So sound marks, if there's a sound mark, a jingle like Britannia's ding ding ding, that's also protected. So if your business is thinking of adopting these kind of marks and you feel with the changing times this helps you stand out, the good news is that this is now subject matter protection under Indian law, and the Indian Trademarks Office protects these. Then color marks. Color marks are a bit difficult to get, but again we've had a number of examples. This is obviously from Tiffany. So Tiffany, so far as it is limited to their area of operation, their products, their class of products, they have monopoly over, and they've registered this particular color for their products, so which basically means no other person in the jewelry business can use this color. The same as with Cadbury. So when we look at a purple for chocolates, they are the only player in the market, because they're very aggressively defended that color adoption by any other competitor. So colors can be protected in India as trademarks. Fragrance is a bit of a new field or new sort of experimentative thing. One of the earliest applications have been filed by Sumitomo for tire that smells of rose, and while this is yet to be tested as to how the regulator, how the trademarks office will treat something like this, But in times to come, what we can only hope is that so long as somebody can demonstrate with certainty that if somebody smells this raw smell in a tire, they'll immediately recall or associate it with Sumitomo's tires. There's nothing further that you really require to convince the regulator to get this registered in your favor. Then some more recent examples are, this is the Taj Mahal Hotel from Mumbai. So IHCL, which is Taj's hospitality subsidiary, has got this registered as a trademark. So whenever you go and dine at any Taj, generally you get the butter on the table. The paper that is used to cover the butter would have this, and other things would have, maybe the menu would have this. So they protected this as a trademark. This is their building, the facade of the building. Some more interesting examples, motion marks. This is also a registered trademark from India. So those of us who deal in probably, some kind of products involving lights or gadgets should think about, if there is an intention to do so, should think about some kind of motion that they could trademark, which is unique. So this is Alexa, of course. When you say, hey Alexa, the manner in which the blue light goes is, the sequence is being registered by Amazon in India as a trademark. So this is just to give you an overview as to what all different things can be used by you to seek protection, so that nobody else copies that in the market. B, as the world becomes increasingly digital, your buyers become increasingly digital and more aware. These would be unique ways to stand out from a marketing perspective regarding your products and connecting with your buyer, other than just using a simple brand which everybody is using today to sell. Just touching upon this, the other kinds of marks, these are collective marks essentially. So collective marks are, for instance, so they're not used to sell a service or a product, but they're used to represent a group of people which assemble or get together for a specific purpose. For instance, a Rotary mark. Certification is BIS, ISI, etc. So used to certify. But these are also protected as trademarks and they're owned by the respective institutions that certify. Point being that besides the fact that under some law it would be a penalty, it would be a penalty to use this wrongfully. Even under the Trademarks Act, if somebody was to just use the ISI logo without actually going through the process of certifying, it would also amount to an infringement of ISI's rights in their certification trademark. This is not so important just because sometimes you would have questions in sessions. What is the difference between trading name, my company name or my proprietorship name, and trademark? So essentially, conceptually it's very similar. A trading name can also be a trademark, because if people refer to you by your company's name, and that has eventually become your brand, your company's legal name, ABC Private Limited or LLP or whatever it may be, can also double up as your trademark. So one classic obvious example is the Coca-Cola company. They started off as that, and the product is also called Coca-Cola, and therefore it's kind of synonymous. So this is the difference between trade and business name and trademark, and the fact that both can be the same, and your trading name can qualify to be your trademark as well. Moving on, this is very important, because most of the queries or most of the people that we represent from the design industry export from India, they have a very simple question or ask every time, which is, okay, we've got our trademarks registered here. Is there a way to get a global registration? Or somebody wrote to me saying, we'll get you a global trademark. So, once and for all, the easiest way to address this is, look, there is no global registration. There's nothing such as a global trademark or a patent or design registration. There are systems and mechanisms which I will talk about and how they can benefit us. I'll just come to that. But first of all, there's no global registration. Why, you ask? Simply because each country is considered a sovereign so far as their prerogative or their right about deciding what trademark to protect or not is concerned. So just because a trademark is protected in, say, Germany, doesn't mean it will automatically be protected in India, or a trademark which is protected or registered in India is not going to enjoy the same rights in Germany. So if I'm trading with a particular brand and I have registered in India and I have goodwill in India and I've been using that brand, everybody knows me in the local markets, in the sourcing markets by that brand. But if I don't formally apply for registration in Germany, it is very unlikely that a German court or a regulator or any other law enforcement agency there is going to protect me against any kind of misuse that happens of that trademark. But so to that extent, trademark rights and IP rights in general are territorial. But countries got together. Obviously, countries and governments are much smarter than we would like them, or we assume that they are. So about 30 years ago was one of the first instances of the most major treaties in IP law having been executed, in India also being one of the 200 odd countries to ratify it. So there are several systems, several treaties. For trademark purposes, there's one major one which is called Madrid. So why Madrid? Simply because it got signed in Madrid, the country was assembled in Madrid. So then it came to be referred to as the Madrid Agreement, and then it has a set of accompanying legal documents called protocol, procedure, this, that. By the Madrid system, what is interesting is any person, any business that belongs to any of the 190 or 200 odd countries which are member of the Madrid system are allowed as a single window to apply to each of the 200 odd other countries. So you can, through your Indian counsel, Indian lawyer or yourself, basically create an account here and file for a trademark and designate whatever countries you want to designate the trademark to. If you only want to, obviously you would not want to apply for registration necessarily in all 200, because what happens is that then you have to also pay government fee for 200 countries. On an average, these days, government fee for a single trademark ranges anything between, say, $125 to $30 to about $300 odd in different countries. India, it's $4,500. The discounted for MSMEs and individuals, and the regular price is $9,000, the regular statutory fee. So assuming you were to apply for registration in 20 countries, and all of those 20 countries are a member of the Madrid system, then it allows you to apply through a single window. Instead of approaching 20 different lawyers in the beginning, allows you to apply through a single window. So what is the advantage, you ask? The advantage is that if that once, so what Madrid does is, Madrid comes under WIPO. WIPO is an organ of the UN, United Nations. WIPO's full form is World Intellectual Property Organization. So like we have UNICEF, we have UNHCR. The UN body that takes care of IP issues is WIPO. So Madrid comes under WIPO, WIPO's administration, and WIPO basically acts as a facilitator and simply marks or sends your Madrid application to each of the, say, 20 countries that you designate. Then after that, it is up to the countries to decide whether to register or not. And they will follow their own process. I'll take you to the process in India. And the process in any other country is also very similar. Most trademark systems, minor differences aside, are functionally, substantially nearly the same. So let's say you market to a Germany, to a France, to an Italy, to a South Africa, all of them are members of Madrid. Assuming their trademark offices don't have any objection to raise, there's nothing. The registration certificate will simply be issued to you and will come to you over email. And that is the main advantage of the single window system. Assuming there is an objection which gets raised, you will then have to appoint a local attorney who has license to practice in that country, not your Indian attorney, because they can't practice with South Africa trademark office or Italy trademark office or whatever. And then address those objections, file a response, and so on. So this is how the international trademark registration system works, or if someone says global trademark, this is what they mean by that. Then there are some regional rights. There are organizations that countries or regions have entered into legal systems. In EU, there is the European Union IP Office, which is an organ of the Commission, and they are basically the organ or the ministry or whatever department that looks at IP rights. And they grant you what is called an EU trademark, an EUTM, which means for each of the 26 states which are a member, you get a single registration. That is possible. To that extent, EU trademark will give you rights over, single registration will give you rights over all member EU countries. And similarly, OAPI is another system which is African. Then there is one for some Middle East countries. They give a common single registration, trademark registration if you want. So this is the global perspective to trademark rights and how they're registered. The other thing to bear in mind at this stage is that rights are gained or obtained by two means. So one is applying for registration, as we were discussing. The other way is by use. Now this is very important. Why this is important is because this is the other most commonly asked question which we get, which is, well, I've been using this trademark in India since 5 years, but I haven't applied for registration. Now when I apply for registration, will my rights deemed to be, deemed to begin from the time I register, or do I, today if I have not applied for it, do I have no trademark rights at all? I have found somebody in the market who mimics my logo and also is using a name which is deceptively similar to my trademark. Does that mean I can't stop them because I have not applied for a trademark registration? So the answer to that is no. In most countries of the world, especially common law countries, which is India, UK, US, New Zealand, Australia, so many others, and even most of the civil law countries, the European Union and so on, we all follow the same system that trademark rights commence upon use. So which means technically you could have started using your trademark, let's say, since 2019. And in 2023, for whatever reason, somebody advises you and you decide to register your trademark. When you decide to register your trademark, you're entitled to claim your rights since the first date you started using it. So your first date of use will become either the first invoice that you issue towards sale of the products for which you want registration, which could be, in your case, handicrafts of various kinds. For instance, let's say, maybe leather products, right? Bags, maybe, or whatever. So, if that's the case, the regulator, the IP office, and in most other countries also the IP office, if you're claiming rights from the back date, will require you to submit some evidence that you were using this since 2019. So, 2-3 different categories of evidences are generally acceptable as far as India is concerned. One is social media ad, because that bears a timestamp. So, with certainty, the regulator is also able to ascertain whether you actually posted that logo on a particular date, that trademark or not. So, advertisement is considered as proof. It could be advertising in a convention like Ihgf, provided somebody keeps photographic proof and there's a timestamp which can be independently verified. So, it could be a magazine, the Fair magazine that your stall got featured in. And that could become, for instance, one way of proving that you were at least on that day using your brand. The best form is, like I said, invoices. If you have started selling and you keep a record or so forth, brand protection and trademark purposes, best practices entail that you keep separately an archive of copies of your invoices, because they are the best proof of the fact that you've continuously traded in a particular class of products under a particular brand. And also make sure to include the brand in the invoice, even if it is not a part of the invoice by default. If possible, if it's a logo that you want to protect, include the logo at the top, because if it's part of the invoice, only then will the regulator believe that logo was also in existence at that point in time. So this is the play between registration and use. When you obviously apply for registration, we'll come to that process a bit later. Just before that, I also want to talk about what kind of marks are protectable, what kind of brands are protectable or not. So, these are two ends of the spectrum. And what happens is, the ones falling on the left side are generally considered as non-protectable. Not just by the Indian IP office, by most IP offices. These principles are uniform, they're universal, they apply to every legal system in the world. So, as an example, now this is a real example. There is a company, there is a business in the UK, mid-size, which obviously over the years then became more popular, which started off as carpet cleaning company. And what did they do? They basically cleaned carpets, So if you apply for registration of the trademark carpet cleaning company, and you're actually cleaning carpets, you're very likely to be refused registration. Because what we have to bear in mind is, what is the purpose of registering a trademark? Registering a trademark basically means that the government is giving you a limited monopoly, or a very strong monopoly, to deal in a particular word and have exclusivity over that word so far as it relates to the category of products that you're selling. So if I'm selling, let's say again, to the same example, if I'm selling leather goods like bags, etc., and I have a brand called ABC, so far as I can demonstrate that ABC is distinctive or arbitrary or fanciful trademark, it isn't descriptive of the goods that I'm selling, and I was the first one to use this in India. The government will give you a registration over that brand, and when they give you a registration, that translates to your ability to prevent others from using that brand, right? So then just applying that logic, you will understand now, or in more context, you will understand why a brand like carpet cleaning company will never be allowed registration, because if they give one party monopoly, how will the others use it? Even in a descriptive sense, how will others use it to refer to their businesses? And even if nobody else uses it to refer to their business, people will call it dry clean, carpet dry cleaning, carpet vacuum, whatever. The fact is, why should the law or why should the regulator favor one party amongst millions of others and give one party the exclusivity over such a descriptive phrase? So that's the logic, which is why these trademarks are considered as bad trademarks. The trademarks on the other hand, so Häagen-Dazs, I presume is a family name, but doesn't mean anything as such, at least in English. So Häagen-Dazs for ice cream and other confectionery is considered to be a very distinctive trademark, because it doesn't mean anything. It's so unique, it's so distinctive. The moment you hear the word Häagen-Dazs, you immediately associate it with the ice cream brand that it represents. And these are generally the kind of trademarks which are easiest to protect and easiest to get in terms of registration. Then there are some names that fall in the middle. I want to take the example of, we'll do questions at the end if that's fine, thank you. For instance, Apple. Apple is, you would say, a common word. So, you just said that common words or descriptive words generic words cannot be registered. But the way to assess this and to to keep this in mind is that if you use Apple to trade in apples or some other kind of fruits, then it becomes descriptive or generic, etc. But if you use Apple for what they do, electronics, that makes it arbitrary. Somebody could have called it pear, somebody could have called their company Orange, as is the case. There is a telecom company called Orange, right? So the point is that it's not so much the commonality of the word, the fact that it's a simple English word, that's absolutely fine, but it should be absolutely random, qua the category of products that you're selling, which then again makes it obviously not as distinctive and easy to register as Häagen-Dazs, but still very easy to register as compared to the others on this side. There's one very interesting example that I want to take here, American Airlines. Now, why I put American Airlines as an example here is, now initially when they would have started off, they would have been a descriptive trademark and a bad trademark to register. But under Indian law, and as is the case with most other legal systems, there is a provision which says, in India, for whoever is interested to read legal provisions, I don't know if anybody would be, but it's under Section 9 and you can search it. So Section 9, there's a proviso, and what the proviso says is, Section 9 says, look, we will not register anything which is descriptive, generic, etc. But the exception to that is that if on the date of application that mark has already acquired a secondary significance or a secondary meaning in favor of that business, that can be subject matter of registration. So in India, I'll tell you where such discretions were exercised. For people who are from, obviously most of us are from here. So Social is one example, the chain of cafes, restaurants. So Social was such a common thing. If you would Google or you would query the Indian trademark registry, there would be a number of social related brands or marks. But to be able to convince the registrar over time that now today, after having launched in some 10 cities or 8 cities, Social, if somebody hears, they will, in the context of restaurants or F&B services, unequivocally associated with this restaurant. That makes for a case under this exceptional category which is provided for under law. And I presume the same category under which American Airlines got registered as a trademark in the US and elsewhere. So this is the chart. Next, you see, I want to briefly touch upon what is the process so that you know. It's not necessary to take help of legal counsel because the systems have been made in a way, or they're meant to be designed in a way that it's easy for owners to apply for a trademark. It's highly recommended that you do, because not because you will not get registration. Not getting registration is a very small problem, because then you can always apply again. The only challenge is that you don't want to end up writing or submitting something to the government, to the regulator, which can be misused against you by a competitor which is self-incriminatory and therefore can be turned around against you. So for those reasons, we advise that you take legal counsel, but should you be interested in doing this yourself, there's no bar and we always encourage. The process is very simple. There are 3 stages to it broadly, and this process is uniform, universal, more or less in every country. It's the same steps, minor differences procedurally or in terms of duration of time, etc. But the first step, obviously, the moment you lodge your application is examination. So what happens is that the moment you put your application in, the trademark office, the department and their officers sit down and they examine your application. They say, look, before this goes out, obviously it becomes public immediately, but before anybody else has a look at it, we will look at it from 2 perspectives. So the same grounds or reasons or factors that we were discussing some time ago as to what constitutes a good trademark. Those are the same grounds on which these people generally test your application or examine your application on. So, very simply put, it's a bit more complex than this, but I've tried to simplify it. There are 2 broad grounds or sections on which they examine and then refuse or provisionally refuse your trademark. The first one is Section 9. Section 9 talks about the fact that they have to prevent the same kind of trademarks, generic, descriptive, non-distinctive trademarks from being monopolized by anybody, even immoral. So, trademarks that have something which has a lascivious kind of flavor or angle to it may be considered as immoral or offensive, and therefore may also be objected to under the same section. So this is one bucket of objections which they raise under Section 9. Once this is done, the second touchstone against which they test your trademark is whether it is identical or deceptively or confusingly similar to an earlier used or earlier applied for or earlier registered trademark. So they will query their database, their own database, and they will generally check. If, for instance, your brand for leather goods was ABC, they will check if somebody in that category, that particular category of products, which is leather goods, is using ABC before you or not. And if they find somebody, then they will also object and say, look, this ABC seems to be, as per government records, seems to have applied for registration in 1978. You only started in 2019. So there's like a 20, 30, whatever, 35-year gap, 20-year gap. And therefore we can't allow you to, because the marks are identical or they are deceptively similar and a consumer is likely to get confused. So these are the 2 touchstones on which they will issue an examination report. After an examination report is issued, you get 30 days to file a response. You have to satisfy them. So you cite case laws or you give reasons. Your reason could be something as simple as that, well, the trademark that you cited from 1978, that business is shut and that trademark is no longer in use. It wrongly shows as registered, or you have by mistake cited a mark which is no longer in use, it shows abandoned. So therefore please waive this objection, or whatever it is. So you submit your response. There is usually a hearing, 1 or 2 hearings that take place, which are virtual. And then if they are convinced about the merits of your case, they will remove the objection cited in the examination and they will publish the mark. Now what is publication? So there must be some place where it gets printed, published, right? So there is a place, it's called the Trademarks Journal. It comes out every fortnight generally, or sometimes every Monday. Every Monday on the IP India website, the IP office website, there is a PDF that gets uploaded with that week's published accepted trademarks. The purpose of publication, this is again a feature universal to every legal system in the world. The purpose of publication is that you or your lawyer should also be watching that. So far as there would be thousands of marks, it's not practical to watch every Monday or every month or whatever even. But at least your category of, because trademarks are divided into 45 categories or classes. This system is also universal. This arises from another treaty that countries have entered into called Nice, which was also signed in Nice, France. So, so we've got very easy names for treaties in that sense. So Nice system entails 45 classes, 1 to 34 being goods and 35 to 45 being services, and like or related services and products are classified in the same class. So clothes are all kinds of clothes, there are also shoes, there are also headwear. They're all, for instance, classified under class 25, right? So they classify like or related products or services in the same class. So what you have to do is basically, if you're doing clothes, you look at class 25, list every Monday or whenever you find the time, or your council finds the time, and see if some third party's trademark is accepted which is similar to yours or not. If it is, then you have every right to, statutory right to approach the IP office and tell them, I want to file what is called an opposition. I want to file an opposition to oppose, to block the trademark from being registered. And because I, for XYZ reasons, have been using the same brand or a brand which is similar from much before this person has been using, after registration, meaning the day your registration certificate is issued to you, you have a period of 5 years and 3 months to use the trademark or to start continuously using the trademark. If you don't use it for 5 years and 3 months, any third person who is interested in your brand can file a cancellation and get your brand cancelled and start using it. So non-use is one, cancellation various grounds. Right? So these are improper licensing. You sell your products to some cases that keep coming, small or big. Some of us from the EPCH community in the past have approached and we looked at cases where, for instance, somebody was exporting, oh, that importer is my friend, we've been doing business for 25 years, they're very good. And then eventually, slowly, first they started to exhibit, they started to use your logo or whatever, without you entering into a proper license of rights, saying that this is my brand, I'm exporting a consignment to you, each of these products bears my brand on the packaging. You will neither remove the packaging, obliterate it, or add your own brand. These are the brand guidelines which you will follow to ensure that my brand is always represented in these dimensions and so on. And what it does is it's not just for royalty, it's not another source of taking money royalty. The point is you document the fact, and if somebody signs a license agreement, even if it's for little consideration or virtually no consideration, the point is if they sign this, they are doing a very important thing. They are admitting that ABC is your trademark. Because that will be the language of the contract. It say ABC, whereas party A is the owner of trademark ABC, party B is the importer, and party A is desirous of giving license and so on. So they are admitting your ownership in that brand. So even for that reason, it's important to enter into a brand license agreement. So these are some of the points to bear in mind as regards loss of rights. This is more technical, we'll skip this. We'll come to the other important topic that I was supposed to address today, this and designs briefly. So copyright, when you talk about copyright, there are dozen things that people say. So I try to break it up and my attempt will be to explain it in the most easy manner, most controversy-free manner that I can. And I'll try to take any questions at the end, assuming we are left with time. See, this is the most debate. This and designs law becomes the most controversial because most of the queries that come around, I created a product, somebody else has created the same. It's not identical, but the concept is the same. So the first thing to remember is that copyright law protects the expression of an idea and not an idea itself. To give you an example that some of us may relate to, who were there and who watched movies from late 80s, early 90s, etc. There was an era where there used to be, and I apologize, it's something very specific to an Indian audience, unless of course you're a Shah Rukh Khan fan or something which is different, which is also pretty believable because I've had so many clients or friends from different parts who watch or follow Indian movies. But in that context, the easiest way to explain, I was just thinking of this example on the way in the car, when I was reaching the Expo Center, is that in that era a lot of movies came and generally different producers would end up taking Shah Rukh Khan and Kajol, that combination, and a lot of them would have the same kind of plot, which is that two people fall in love, there's both come from a different economic background, then they abscond or they run away to Switzerland or some similar European country, and then there are songs, and then the father of the girl sends like her brothers or something, and so that theme followed for a good maybe like 8 or 10 years as far as I know. So 5, 6, 7 major movies had the same theme. The point is, under copyright law, if one could protect an idea, then probably Yash Raj Films or whoever was the first one to think of that concept or that plot would have claimed exclusivity in a plot. Unfortunately, copyright law doesn't allow us to protect ideas. So now let's relate. So what is protected in that example? I quickly just go back to that example and come to our industry and take some specific examples. So what is protected? There is the dialogue delivery, the sequence of events, the costumes, the dramatical works, which is the dance choreography, the difference in the songs, their lyrics, and so on. So all of that is what is protected, not the plot itself. Now if you take that example home here to our field, what happens is that, for instance, some years ago somebody told me that we are doing this, we were the first ones to do this light, and that light was basically like a paper-based or cardboard-based lamp, which was in the shape of a tree, right? And there was a lamp like a bulb, place to place a bulb in between, and it was really neat. It could be folded up, and it was really light, and people could export it, and became really popular in a certain part of the world, in Europe or wherever. So they said, look, we were the first ones that thought of putting the lamp in that fashion. And now what has happened is other people have copied the idea, and they are coming up with lamps and trees again. So when we had a look at the competing products, we realized that those trees are completely different from the depiction of the original product that particular exporter from within EPCH community had actually created, and they were complaining that, boss, what is this? So what we tried to explain was that, somebody's liked your idea of, fair enough, you were the first one to think of putting this in a tree kind of model. But their tree has ended up looking very different from your tree. Therefore, there is no exclusivity that you will get under copyright law. So far as the application of tree design or the shape of a tree to an article is concerned, to let's say lamp is concerned, that will come to design law. And there are very limited, again, grounds of protection that are given. But in copyright, you don't get that. So we looked at idea expression dichotomy. The other thing to bear in mind is what are the broad 4 categories, 2 subcategories, 2 secondary categories that are protected. Literary, dramatical, musical, artistic. Dramatical not so relevant for this audience, for us here. Literary, anything that you write, even your product manual, if there is a product manual, your brochure, your write-up on your website, everything which is except slogans, etc., those are very small. Those are considered very minimal. For them to be given any kind of copyright protection, those can be protected under trademarks, as we saw, just do it, etc. But anything which is substantive, 1 para, 2 paras, 2 pages, 200 pages, whatever it may be, all of these can be protected as literary work. And then dramatical is different, dance performances and theatre and everything. Musical work is not sound recording, I'll just come to that. Musical is the actual notes that comprise of a tune. So when you hear a tune, regardless of how you play it or what instrument you play it in, the musical composition is actually the notes. So that's also protected. And artistic works, this is what is most relevant in our case. We've taken, my colleague here who assisted in making this, assisted me in making this, has taken some jewelry examples. So for instance, this particular Cartier design of a ring has a peacock feathers here, inspired by, his design is inspired by peacock feathers or whatever. And then there's a braided thing. So this obviously is both subject matter protection as design, but if you miss the bus, we come to designs now, if you miss the bus, published it first, then you can by default protect it under copyright. So, so artistic works, this would be considered as, the sketch would be considered as an artistic work, and similarly that would be considered as an artistic work. The other important thing to, okay, so then very quickly the 2 subcategories are sound recording and cinematograph. Why they are secondary to the primary 4 works, LDMA, is because they are made up of a combination of one or more of the primary works, which means sound recording is a song, what we hear, like in the car or wherever. So why it comprises of different things is because it has music, so that music relates to musical work in the notes that are used to, compose a tune, and then it would have lyrics. If it has lyrics, then that the lyrics are protected as literary work. Same with cinematograph films, which are movies. There's dance, so there is a dramatical work, combination of artistic, musical, literary work, and so on. So these are the different categories of things. Photographs are also protected. They're protected as artistic works under Indian law. Other countries there is a separate category for photographs. Now, before we move on the next slide, at this juncture it's very important to know how the law is structured in terms of who is supposed to be the owner, who can claim to be the owner in the first instance, the second instance, how do you take care of that, because that becomes very important. Many of us work with designers or people who are outsourced, so we work with them on a principal to principal basis. We don't have in-house designers at times, or we would deliberately want to work with somebody outside. So this is a thing to bear in mind. The person who creates a particular artistic work or a particular design or whatever is, so the word used in law is author. Author is singer also, author is lyricist also. A uniform word in copyright law world, which is author. Everybody is an author. So the person who designs will be considered as an author, right? And authorship is important from two perspectives. Author, the creator is considered to be the owner in the first instance. By default, they are the owner. Unless there is something to the contrary which leads us to the point that he or she is not the owner, which could be, and which is what is important for us to bear in mind, that if we have agreements, once we have employed somebody, we should definitely agree in writing with them that their fee or their compensation includes the fact that they are making this for us, or what is referred to as the work for hire doctrine. They are being compensated for making this custom to our requirements, and therefore all intellectual property, including all copyright in what they create, will in the first instance vest with us. So then you ask, what other purpose is authorship important for? When you file a copyright application, if you file a copyright application, when you file a copyright application, it requires you to identify a person as an author. Now, just because you purchased this copyright from them or you made it under a work for hire arrangement doesn't mean you can automatically identify yourself as an author. You have to nominate or identify that person, even if they're outside of your organization or they left you, they were an employee or whatever, and you will be required to submit their no objection certificate along with whatever agreement you do. So you should, at the time of doing that agreement, also do like a standard no objection certificate that so and so has no objection that you apply for registration of this as copyright in one go, because tomorrow when people goes and nobody cares, then you keep chasing them, nobody executes it. So this is why this thing is important to bear in mind. The law has been designed in a way that the author is considered as the first owner, so you should have a documentation in place to ensure that rights are transferred. The tenure of copyright is lifetime of the author plus 60 years, which means if your author dies next year, right, God bless him or her, but if they die next year, the person who created it, too bad for you, you'll only get 60 years from their death. If they live for another 20 years, 30 years, whatever, you'll get protection for their lifetime and then another 60 years after their death. So this is how the tenure is calculated, so therefore it's very variable, it depends on the life of the author. There's no requirement for registration, unlike trademarks. Of course, trademarks also, like we said, rights begin with use. But why I'm saying here no requirement for registration is, if trademark rights are infringed, you have to be registered in order to claim a specific kind of relief from law, from courts, which is called infringement. If you allege and you say that so-and-so is infringing my rights, infringement is not a common English term in the legal context. It's a very specific term. It is used to refer to only those categories of rights that are registered. Exception being copyright. Copyright, you don't need registration to initiate an infringement action. So this is because, traditionally, if somebody is curious to know why there is an exception that lawmakers did for copyright, copyright was seen to be a poor person's intellectual property right. Painters, artists, craftsmen, artisans, etc. And therefore not so commercial in its application as patent or industrial designs or trademark would be. Then another important, Bern Convention is one of the conventions that countries agreed to got together in Bern and then had the Bern Convention. So again, 210 plus countries, I think 209 plus countries, including India. A very important feature, if something is subject matter protection in India, you automatically get protected for it in any of the 200 odd Bern member countries, which means for copyright, for somebody violating your, unlike trademarks, what we discussed, unlike trademarks in copyright, if your copyright is valid in India and somebody copies it, you export it to say Poland, and somebody copies it in Poland, you are allowed to enforce it. Not just that, Polish courts by Polish law will be by force required to enforce your copyright as if it was the equivalent of a Polish copyright in Poland. So that is what the Bern Convention entails and requires countries to do. And the good news is most major economies are member of Bern Convention. Another important provision of copyright law in India is that what we saw here, this was obviously it's a 2D image, right? But what copyright law says is that if you are protected, then a 3D rendition of this 2D image, 2D object is also protected. So nobody can take this and then make an actual ring in this shape in 3D, like an actual object out of it. They will still be considered as violating your copyright in this sketch because they created a 3D image, which is a 3D rendition virtually of the 2D object that you sketched. So this is, and it applies both ways. If you've protected a 3-dimensional object and somebody makes a painting of it or clicks a photograph of it without your consent, that's also infringement, of course. So 3D to 2D, 2D to 3D, both ways is protected. Section 52 is a very important provision that provides for exceptions. It's a very long section. Some of the most notable ones are education use. So a lot of design schools would bring up your designs sometimes. You can't object because under law, under section 52(1)(i), there's an exception for design schools or anybody. The language used is in the course of instruction between a teacher and a pupil. Anything that you reproduce which is protected by copyright law is not considered as infringement. So with this, this was the extent to which I wanted to cover copyright. Design is the last bit. Design is very important. There are 2-3 things to remember in our context about design laws. One is that designs need to be novel. Novelty is the first requirement in designs. And by novelty, what is meant is that it should not be prior published. Which means nobody should have done even a convention kind of release, limited release or a white paper, or even your own like self-publication or self-release, release a product into public, which you sold it. Then try to apply for a design will make the design liable to be cancelled merely on novelty grounds without going to whether it is creative enough or not. So novelty is the first requirement, and unfortunately the most common reason why designs get cancelled or come out of the design registration. There's no remedy for it. Once you lose design protection by publication, it is lost forever. Then you automatically fall under copyright. Under copyright, there's a limitation as to that design being applied to a product mechanically to an extent of 50 copies. So for very high value items, 50 copies is okay. But for mass items, beyond 50 copies, the moment you create a 51st copy, bearing a design, your entire copyright goes in the public domain. So if you look at this example, this is again an example from one of the cases we're working on. This is a campus shoe company that we represent. We got instructions to, this is public so I can talk about this. We got instructions to file for design protection of this shoe, right? So for whatever reason the legal team there or design team there thought this would be, and it is, to that extent it is something which is design worthy because it's a pattern which is applied to an article, which is the shoe, and therefore this is an extract of a particular page, the manner in which we endorse or talk about what is unique in this. Now please see at the top, I know probably you can't see, so I'll read for everyone's benefit. Top is an extract of the examination, same process gets followed, what we talked about in trademark. Application, examination, then hearing, then acceptance or rejection. So here what the design office did was, they did a Google search and they brought up our client's shoe, this entry from Flipkart, and annexed this and said, look, this shoe was filed by you for registration on so and so August, 14th August 2024. Here is a Flipkart rating, Flipkart listing, and in the rating and reviews column there's somebody who's purchased this shoe and rated you 4 stars way back in February 2024. So which means that you were at least in February 2024 selling this because somebody's already purchased it in February 2024. So we said, but this is self-publication, I only have sold it. So they said, no, the law is very clear. If you have sold your own product, you will not be allowed to register it. So that is a real objection, and this resulted in a rejection, outright rejection, which we couldn't even appeal. This is a real extract from an examination report which my colleague has pasted there, showing that this is how designs are refused protection if you miss the bus. Coming back very quickly to what aspects are, apart from novelty, what is protected is you have to qualify for novelty, and then it has to be creative. And what is protected is, this is the terminology used under Indian law. Shape, configuration, pattern or ornament. Now each of these is very for us to spend a few seconds and view these with importance, because each of these has a different significance. Now in some cases, the shape would be very simple. So this example here is the Moti Bharat work, of somebody doing beadwork on a very standard article, which is a very standard shape, rectangular shape or a square shaped pillow case. So when you file a design application claiming design rights in this, you will not be entitled to claiming any rights in the shape. Because what is there in the shape? What is unique about your shape, your product? This is a square shaped pillowcase, and that is how every pillowcase looks, more or less, right? So we will never claim exclusivity in the shape, but what we claim exclusivity or can claim exclusivity is in the pattern or the ornamentation. Because the pattern or the ornamentation applied to the shape or applied to the object is what makes it unique. And therefore to that extent, we will be getting rights, if at all, when the design gets registered, to the extent of what beadwork has been applied and what configuration, pattern or what ornamentation. In some cases the shape may be unique, assuming, I know it isn't, but assuming this was a unique shape for a candle stand, right? If you were dealing in candle stand and this was a unique shape, you will be allowed to protect both the shape as well as any pattern. If you were to put a pattern or ornamentation on this, you will be entitled to protection of both the things. The shape of the product itself as well as the design or the pattern applied to the product. So they are distinct words, and therefore the distinct words in law each have a different meaning. The design has to be applied to an article in 2D or 3D, which is fine. You could consider this, I don't know, maybe barely 3D. Basically, block work or print work would be absolutely 2D. Other things like these, like Jada or these, would be 3D, for instance, and so on. And the requirement is that it must be applied by an industrial process. This is very easy to qualify. Everything we do today is applied by industrial process. Industrial process doesn't necessarily mean by machines. It can be by hand, it can be a combination of machines and hand, and so on. So this is an overview of how designs are protected. Another important thing to keep in mind is, like trademarks, there's nothing called global design rights. Nothing. No global registration. You have to qualify for registration in each country. Like we had the Madrid Convention for trademarks, we have the Paris Convention for designs. And that allows us a period of 6 months from within the first country that we apply to. So if you applied for registration in India first, then we want to apply in 6 other countries. We get a period of 6 months to apply for design registration in each of the target countries, and then after that, novelty is breached. So this, another thing to bear in mind is that only the aesthetic aspect is protected, not the functional. So which doesn't mean that a design cannot be functional, obviously. So if you look at that chair there, certain elements of the design would also be contributing to how comfortable that chair is or how ergonomic it is. The only thing is that how comfortable or ergonomic the chair is cannot be one of the factors that you claim exclusivity over in your design application. Now the shape so far as its aesthetic value is concerned, the shape of that chair can be protected by you, provided it is new, it is unique to you, you thought of this for the first time. In the middle is the Manish Malhotra lehenga. It's an extract from their actual design application. Nothing unique about the shape of the lehenga, but the ornamentation, the pattern, same example that we talked about before. This is a Tony's chocolate only, very unique shape, because, and they've run many ad campaigns about the weird shape in which they're broken up there. So it's very different from a, say, a Cadbury's, the way you would find squares on a Cadbury's or any other bar, Milka, etc. So the shape of this, including, so not the rectangular shape, but this shape is protected as a design. Same with these shoes, for instance, these are Ihgf's or whatever. Yeah. So these are also subject matter protection. The duration of design law, design protection in India it varies with each region, each country. In India, it's basically 15 years, 10 plus another 5 on renewal. And after 15 years, it goes to the public domain. And the reason behind that is the lawmakers want to maintain a balance between social need for design, students and designers to innovate and improve upon old designs which are classic. Most important example being Cartier, of course, is being misused as well. The Cartier band design, yeah, the lock and the key. So that obviously has fallen into public domain, which is why you'll see every jeweler in the city, in the country, make a band in the same design. And then improvise, and that's partially the objective of law, to keep it only 15 years. So this is another case, and then I'll probably just wrap up after this. This is very recent, Delhi High Court 2022, filed by Bulgari against a local jeweler called Nutan Das. So again, what they said was, Nutan Das basically made also a serpentine kind of bangle, like a band. And what the court, while protecting Bulgari's rights, said was that because Nutan Das had challenged the novelty in the shape, or they had said that there's nothing unique about the shape or the pattern or not. So court actually, in its observation, by looking at and understanding the perspective of what Bulgari had to say, noted that these designs are not merely in the shape of a serpentine, and that's not the only remarkable thing about them. In fact, that's the most common thing about it, that is shaped like a serpentine. But because the other side had produced evidence of Egyptian paintings and everything with people wearing actual snakes around their hands, or bangles shaped like snakes, etc. made of wood. But what the court said was that if you look closely, and I'm not sure how clear it is, they talked about 2-3 things. They said, one, that it's not merely circular. It has been made in a way that if you were to buy multiple bands, they would fit very perfectly, so that the face of the following serpent would fit or lock into the tail of the space between the tail of the previous serpent, right? So that was what was unique in this, and the court recognized and protected that aspect. Next, they said the placement of gems here. So 9 gems placed in a trapezoid manner. It could have been straight, it could have been triangular, it could have been rectangular, whatever it is. But this configuration, then alternating it with a stone, like some kind of black stone and diamond in this. So these taken together made it unique and therefore design protection worthy. So this was one. 50 copies I've already talked about. If you miss the bus as regards design protection, then the only fallback is copyright. But copyright says, because there is an overlap, and we began with that, there is an overlap in copyright and design law, but how the lawmakers have tried to resolve this is, they say, you should by default apply for design protection if you think your design is worthy of protection under Industrial Designs Act. If you for some reason did not, then you will only be able to make 50 copies of it. And the moment you make the 51st copy, then you lose exclusivity over the design. Then anybody can copy yours. Then you don't get anything under copyright law, because if that were the case, then nobody will apply for designs law. Everybody will protect it default under copyright law, and there's a big difference in tenure. Designs law, they want to protect it only for 15 years and then make it publicity juris. Here you will keep it for lifetime plus another 60 years and monopolize it. So, which is why this strange provision is there. Patents is not so relevant. At the end, just a couple of thoughts. GI, very quickly, I want to touch upon GI. You see, some examples here: Kanchipuram silk, Chanderi sari, Indore, leather toys, Ratnami save, again more stuff from Madhya Pradesh. There's so many examples. The thing to bear in mind for GI is that GI is a community right. No one company or producer or whatever. It's a right which is generally, today if you see the patent, it is being applied for by various trade promotion bodies which are autonomous or backed by government, and they're applying on behalf of artisans or communities of artisans, and those people are then getting rights. So each GI registration would have certain conditions. So for instance, Kalkatti jewelry would have conditions that the artisans need to be geographically located within Calcutta, and it needs to be sourced from, the material needs to be sourced from silver which is available in Calcutta, whatever, XYZ. So those conditions, so long as we abide by, anybody can use the same GI. We can call our sari or our toys Channapatna toys, so long as they are sourced from there and they comply to the Channapatna standard. GI will skip. Infringement, very briefly, if somebody violates your rights, you can approach the court. Injunction, we said. Two most commonly sought reliefs are, you can ask for a stay from the court. The damages, you can file or strategize your law action in a way that you get a behind the back, what we refer to as ex parte injunction, get a local commissioner appointed and do a surprise search and seizure of evidence if you get information that large inventory of your products, counterfeit or violative of your design rights or copyright, are being stored somewhere. And then obviously it's also a criminal, so copyright and trademark are criminal laws as well, so there is an imprisonment and penalty. So you can file a complaint before the police or the magistrate and get into criminal proceedings as well. Best practices and strategies, we follow what is called a SAPED thing, SAPED. Very simple to remember. S is for search. Before you launch a product, you should conduct a diligence or a market survey or a conflict search in the government legal registers to see if that product has already been registered or applied for by somebody else. Apply, ideally before you launch a product, for the reasons we discussed, you should apply for registration. Same with your brand and so on. Protect, of course, you should, once you apply, you should ensure that you obtain a protection so that you're able to enforce your rights, which follows E, enforce, that the moment you see, for the reasons that we said, we looked at the loss of rights slide. If you see rampant infringement of your rights, whether it's your brand or it's your design, and you don't take action, after a point in time, your design will become common, and then you will not be able to take action, because courts will say, people will bring evidence, all kinds of evidence to courts and confuse them and say, "Ye to market mein bahut sari jagah pe kara hai." So enforce at the first instance whenever you see anything that is going wrong. And then defend, obviously set up a strong defense strategy, which is a combination of how you do your documentation. We discussed some parts of it with your counterparts who are importing your products or other people you're licensing your products to, and to ensure that that thing is tied in. Also with your artisans or your people who are producing for you, you ensure that the flow of rights is very clear, the flow of title from them to you. So this is an overview of what there is. You already have the designs register, which is better than having an independent. I mean, this is one company that people in India, businesses in India started to use. Whitney, they're Swedish, they're one of a kind. But a better example for you all exists in the form of the designs register, which the EPCH launched. Because EPCH being an independent body, what is the point of blockchain? Blockchain, basically, the thing to bear in mind is that it is independent proof or somebody time stamping the existence of something. Same thing EPCH does with as much, if not more, authority. So better way is, at the very least, whatever working designs you have or anything. And I understand how the EPCH design register works from Rajesh ji. I've understood in the past is that it can also remain confidential. If there are any designs that you upload, they are timestamped. And once a design is infringed or some dispute arises, especially amongst the members of EPCH, you can draw those designs out, and EPCH can be proof of the fact that it was uploaded on that particular date and so on. So this is what I had to talk about. AI is something which all of us, where I leave with this thought that AI has come up everywhere. So what you have to bear in mind is you have to be sure. So as far as India is concerned, this is a very complex question. What is the interplay between AI and IP in India at the moment? But what you have to bear in mind is that as far as India is concerned, as late as February 2024, the MOS Commerce, the Honorable Minister of State Commerce, had to a question in Parliament made a very specific statement saying in India we intend to protect the outcome of AI generated copyright, But it's not as simple as that, it's very complex. So from your perspective, what you have to bear in mind is, you can use tools, a lot of people are using tools to generate designs and so on, which is fine, but the challenge is if the output ends up looking like somebody else's, because each generative AI model has been trained on millions of images. So whether we like it or not, some output will end up looking heavily inspired or deceptively similar to one or more of the images it was trained on. And if that is the case, then you will be found guilty of infringing somebody else's rights. So you have to be very wary of to what extent you use AI, while not shedding it away, because adopting emerging technology is more important, riding the wave, than to be cautious, over-cautious or not. And also to ensure that your vendors don't use designs that are AI generated and belong to somebody else and so on. So you could build in sufficient declarations or undertakings in those agreements saying that you have not used any generative AI tool, or if you have, you undertake to compensate us in case there is a third party that brings an action against us. So this brings me to the end of the session, and time permitting, I'll be happy to address any questions that anyone may have. Thank you. Yes.
Another brand. It was not sounding similar name, was having a different identity. So what's your view on that?
If you actually, in fact, if there is internet, I can quickly bring it up and show you.
So can you just brief us about the case and then you can answer, because for the benefit of others, what was the case?
Of course. Let me just check if there is internet here. Somebody can assist me. I just want to. It's there on the internet, and we can probably just see. So basically, it concerns the Gems, Cadbury's Gems product. The Gems has a square, not a square, rectangular box which has colorful representation of gems there. Gems, the candy, the chocolate little pebbles that Cadbury's manufactures. And essentially, this was another brand that made, so that's Gems, this was James Bond. The thing was, he's correct so far as his inability to agree with the quote, pronounce the words with that amount of difference, or be able to discern between how to pronounce James different from Gems. In Gujarat or so many places, James would be Gems, Gems would be James, right? So that was the reason why they injuncted it.
Thank you very much. अंकित जी, वैसे तो हमारी कंपनी आपसे ऑलरेडी काम कर रही है, मेरा एक क्वेश्चन है जो आपने ऑलरेडी उसको डिस्कस कर लिया, रिप्लाई कर दिया है। आई वांट टू रीकन्फर्म दैट अगर हमारे पास एक प्रोडक्ट का फोटो कॉपी है और उसके साथ इनवॉइस भी अटैच है और वो नोटरी अटेस्टेड भी है कि 10 साल पहले हमने ये शिप करा था, that is already that is a real evidence कि that पहले बना हुआ।
जी सर, तो अगर फॉर इंस्टेंस आपके सवाल पे कि एक प्रोडक्ट है उसकी हमारे पास फोटोकॉपी है,
वो टेस्टेड है नोटरी से कि इस डेट पे ये भेजा है
जी, तो अगर सर नोटराइज्ड होगी तो नोटरी इज कंसिडर्ड एज अ सिस्टम। जो गवर्नमेंट अपॉइंटेड होता है नोटरी, जो लॉयर होता है,
नंबर भी होता है,
उसमें नंबर और अगर अपना रबर स्टैम्प मारा है उसमें डेट होती है,
डेट भी और नंबर भी है जो रजिस्टर में,
तो बिल्कुल वो प्रूफ माना जाएगा कि उस दिन एक नोटरी ने विटनेस किया, अगर उसने फोटोकॉपी को विटनेस किया और आपने सर्कमस्टेंशियल एविडेंस ये दिखाया कि ये इनवॉइस मेरे पास है जी, और दिखाने का इनवॉइस में कोई तरीका नहीं है कि शिप क्या किया गया, हाँ जी, लेकिन अगर आपने वो रबर स्टैम्प के साथ नोटरी की ओरिजिनल रख लिया, दैट इज अ वेरी गुड वे टू प्रूव the fact that a product existed.
Okay, that is clear evidence. इसके अलावा एक और जनरल क्वेश्चन आता है मेरे पास में जब ये ऐसी कोई सेमिनार होती है
जी,
कहते कितने चेंजेस नजर आने चाहिए एक प्रोडक्ट को दूसरे प्रोडक्ट के कहने भी ये इसकी कॉपी नहीं है
जी,
कोई कहता 12 चेंजेस हो, साइज चेंज हो, कलर चेंज हो, कुछ भी, तो कोई ऐसा नंबर है क्या?
नहीं सर, अनफॉर्चुनेटली नंबर नहीं है, बट ये बड़ा रिलेवेंट सवाल है एंड आई वांट टू थैंक यू फॉर आस्किंग दिस। जो डिज़ाइन लॉ की इन्फ्रिंजमेंट की अगर बात हो, अगर जो सब्जेक्ट प्रोडक्ट है अगर डिज़ाइन लॉ में रजिस्टर्ड हो, तो डिज़ाइन लॉ में कोड क्या कहता है, उसने टेस्ट होल्ड किया, ये सारे बड़े सब्जेक्टिव टेस्ट हैं, इसमें कोई ऑब्जेक्टिविटी नहीं डाल सकते, 4 चेंज 5 चेंज, 1 कलर 2 कलर व्हाटएवर। इसमें सर कोड ये कहता है कि हम इंस्ट्रक्टेड आई टेस्ट फॉलो करेंगे। इंस्ट्रक्टेड आई टेस्ट को कैसे डिस्क्राइब करता है, वो ये कहता है कि अगर कोई इंस्ट्रक्टेड आई का आदमी है, यानी इफ दैट पर्सन इज समबडी हु बिलोंग्स टू दैट फील्ड, अगर उसको एक प्रोडक्ट देखकर दूसरा प्रोडक्ट सिमिलर लगता है तो हम इसको सिमिलर मानेंगे। अब कोर्ट कैसे अराइव करती है, देयर आर वेरियस वेज ऑफ इवैल्यूएटिंग एविडेंस। वो कई बार आपको डायरेक्ट करेगी दोनों पार्टीज को कि आप एक एक इंडिपेंडेंट एक्सपर्ट से एक स्टेटमेंट लाइए, टेस्टिमनी लाइए कि उनकी क्या स्टेटमेंट है, इसको देखकर कि एज एन इंस्ट्रक्टेड आई पर्सन, एज अ पर्सन हु बिलोंग्स टू दैट फील्ड, उनको एक प्रोडक्ट देखकर डू दे गेट अनमिस्टेकेबली do they connect it unmistakably with another product that they've seen previously? तो that is the test। उसमें एक चीज, दो चीज, चार चीज चेंज करने वाली चीज है नहीं, मतलब कोई ऐसा टेस्ट नहीं।
एक बड़ा बेसिक किसी ने पूछा था, कोई ऐसी इंश्योरेंस कवरेज है वर्ल्ड वाइड की जो जनरल जैसे इंश्योरेंस हो, जैसे हम पीसीजीसी करवा लेते हैं, तो ऐसा भी कुछ है वर्ल्ड वाइड की भी हम उसकी भी हमारी कंपनी की कोई कॉपी आईपीआर के ऊपर कॉपीराइट को प्रोटेक्ट करे, और कभी कुछ हो तो वो अपने आप इसको लाइक इंश्योरेंस होता है ऐसा कुछ?
जी, टू माय नॉलेज सर नहीं है, लेकिन आप इंश्योरेंस मांग सकते हैं कुछ कुछ लीगल सिस्टम्स में। इंडिया में तो जितना मेरा लिमिटेड अंडरस्टैंडिंग, आई एम नॉट एन इंश्योरेंस लॉ एक्सपर्ट, लेकिन आईआरडीआई इस तरह की कैटेगरीज पे इंश्योरेंस देना परमिट नहीं करता है इंश्योरेंस कंपनीज को, जनरल इंश्योरेंस कंपनीज को। कई कंट्रीज के सिस्टम इतने इवॉल्व हैं कि वो आप मांग सकते हैं, अगर आप इम्पोर्ट कर रहे हैं कि मैं आपसे कंसाइनमेंट ले रहा हूँ, और अगर वो रास्ते में ओईसीडी रूल्स के तहत कहीं पर आईपी इन्फ्रिंजमेंट के क्लॉज की वजह से कहीं पर वो शिपमेंट रुक गई, तो आप मेरे को कॉम्पनसेशन देंगे, आपकी इंश्योरेंस कंपनी देगी फॉर दोज लिमिटेड पर्पसेस पर्टेनिंग टू आईपी राइट्स। कुछ इंटरनेशनल इंश्योरेंस कंपनीज हैं जो डिफरेंट कंट्रीज में इंश्योरेंस देती है कि अगर वो वायलेटेड पाया गया और वो रुक गया कंसाइनमेंट बिकॉज ऑफ वायलेशन ऑफ आईपी राइट्स, तो हम देंगे, क्योंकि हमने एज एन इंश्योरेंस कंपनी डिलीजेंस करके सेटिस्फाई हो गए हम कि ये प्रोडक्ट जो भेजा जा रहा है यही प्रोडक्ट है और इसके राइट्स ये ओन करते हैं।
एक क्वेश्चन आता है कि जैसे से अब पेप्सी है, पेप्सी जो बनाती है जो सॉफ्ट ड्रिंक, तो हम पेप्सी की चप्पल तो बना ही सकते हैं कि नहीं?
हाँ सर, तो ये बड़ा इंपॉर्टेंट सवाल है। जो हमने वेल नोन और फेमस ट्रेडमार्क्स की बात की, उस कॉन्टेक्स्ट में ये आता है कि अगर आपका ट्रेडमार्क वेल नोन और फेमस है, तो पेप्सी अगर चप्पल नहीं बनाती तो आप पेप्सी के नाम से चप्पल नहीं कर सकते, ना फोर्स कर सकते पेप्सी को कि वो चप्पल बनाए और फिर उसको राइट मिले। एंड देयर इज अ स्पेसिफिक टर्म और कैटेगरी इन लॉ कॉल्ड वेल नोन ट्रेडमार्क, वो डिफाइंड है। तो आप एक बार वेल नोन ट्रेडमार्क हो जाते हैं तो उसके बाद यू आर प्रोटेक्टेड फॉर ऑल काइंड्स ऑफ गुड्स। बट अब कोई कॉमन वर्ड है, प्राइम है, एक्स है, वाई है, सुप्रीम है। सुप्रीम एक गलत एग्जांपल है क्योंकि बड़ा फेमस हो गया डिजाइन हाउस, बट अगर सुप्रीम होता, अब सुप्रीम प्लास्टिक्स भी एग्जिस्ट करता था, सुप्रीम चेयर भी करता था, सुप्रीम कुछ और भी करता था, तो उसमें फिर प्रोडक्ट स्पेसिफिक रजिस्ट्रेशन।
अब एक और जनरल क्वेश्चन लास्ट प्लीज।
जी जी।
अब मान लो हमारे कोई प्रोडक्ट के ऊपर हमने कोई एक नाम हमारे हमने कॉपीराइट करवा रखा हो,
हाँ जी,
तो उसका कोई और उस नाम से फोटो फ्रेम है
जी,
हमने हमारा एक रेजिडेंट के नाम से फोटो फ्रेम है,
जी,
तो कहीं हम देखते हैं कि वो लोग और भी उस नाम से बेच रहे हैं,
जी।
तो हमारा ट्रेजर है कि उसका जो मार्क है वो कॉपीराइट हमारा दोनों ही है, तो उस केस में क्या आप समझते हैं कि फोटो फ्रेम तो सारी दुनिया बनाएगी, रोक तो सकते नहीं है, बस उसका डिजाइन की बात आ रही है, पर स्पेसिफिक हमारे जो कॉपीराइट में आप नाम उसमें तो फोटो फ्रेम लिखा हुआ, डिजाइन तो लिखा नहीं हुआ।
जी जी। अगर वो उसको एज अ ट्रेडमार्क यूज कर रहे हैं,
हाँ जी,
एज अ ब्रांड यूज कर रहे हैं उस शेप को या उस डिजाइन को,
हाँ जी।
तो आप ट्रेडमार्क लॉ में एक्शन ले सकते हैं। जैसे
अगर फॉन्ट चेंज कर लेते हैं तो
कोई फर्क नहीं पड़ता सर, अगर वर्ड आपका
हाँ
है फॉर
जी,
इंस्टेंस
हाँ,
और आपने यहाँ पर ट्रेडमार्क रजिस्टर कराया है, वो फॉन्ट चेंज कर लेते हैं
एक ही कैटेगरी में अगर कराया है, दूसरी कैटेगरी में नहीं कराया है, किस
तो हाँ जी, तो अगर सपोज कीजिए आपने सिर्फ क्लोथ में करा है, बट जो लोग आपको मिले हैं वो लेदर गुड्स के लिए मिले या आपको कुछ और फर्नीचर के लिए मिले, तो उसमें टेस्ट कोड क्या लगाती है, मतलब ये सारी इम्प्रोवाइजेशन कोड के एंड से हुई और उसके हमें क्रेडिट देना चाहिए जुडिशरी को। उसने कहा कि देखो ये नीड्स क्लासिफिकेशन में हमने डिस्कस किया 45 क्लास का बकेट वाला सिस्टम, तो ठीक है कि आपने जितने क्लास में अप्लाई किया आप उसके लिए रजिस्टर्ड है, बाकी किसी के नहीं है अनलेस यू आर अ फेमस एंड वेल नोन ब्रांड। लेकिन अब उन्होंने कहा यार ये तो बड़ी नाइंसाफी है, जैसे आप एग्जाम्पल दे रहे हैं। अब वो ये टेस्ट वेरियस टेस्ट अप्लाई करते हैं, एक टेस्ट अप्लाई करते हैं कि अगर ये गुड्स अलग अलग कैटेगरी या क्लास के, लेकिन ये बिके जाते हैं सेम चैनल ऑफ ट्रेड्स। फॉर इंस्टेंस ये सेम तरह की कन्वेंशंस में, कॉन्फ्रेंसेस में और एग्जीबिशंस में साथ साथ में स्टॉल में होते हैं। तो जैसे कोई जनरल ट्रेड कन्वेंशन होती है, जैसे भारत मंडपम में होती है हमारी जो IT, उसके अंदर तमाम कैटेगरीज ऑफ प्रोडक्ट्स होते हैं, बट उसमें फार्मा नहीं होता, केमिकल्स नहीं होते, उसके अंदर एक ही तरह के या 10 तरह की चीज़ें होती हैं। वो भी एक टेस्ट है दैट इफ यू आर रेगुलरली सेलिंग अ प्रोडक्ट्स थ्रू द सेम सेल्स चैनल। एक ईजियर एग्जाम्पल इस किराने की दुकान पे 20 तरह की चीज़ें मिलती है, साबुन भी मिलता है, चिप्स भी मिलते हैं, बिल्कुल सेम नहीं, लेकिन बिकॉज दे आर सोल्ड एट द सेम काउंटर थ्रू द सेम सेल्स चैनल, द लॉ विल नॉट परमिट in your case if you are registered for one category for another person to use their brand for another category of goods. But what you have to demonstrate is कि आपका कहीं ट्रेड में रिलेशन या चैनल ऑफ ट्रेड जो है वो मिलते जुलते या बायर मिलता जुलता होना चाहिए।
इसका मतलब कोर्ट का जो एक्चुअल जस्टिस का एसेंस है
जी।
कि कहीं जानबूझ के इसको गलत यूज हो रहा है
जी।
तो वो जजमेंट है
100%। और अगर
अदरवाइज कोर्ट को लगता है कि इनकी इंटेंशन गलत नहीं थी
जी
तो उसका डिफरेंट हो जाएगा।
सर एक उसमें एक्सेप्शन है, इंटेंशन देख ही नहीं सकता, कोर्ट देखता
नहीं, वही डिस्क्रिप्शन तो कोर्ट की आ गई ना कि इन्होंने जानबूझ के इसको कॉपी करा है,
बिल्कुल।
इनको मिसयूज करा है
जी।
अगर उनको लगा कि ऐसा इसके अंदर नहीं है तो
जी।
नेचुरली वो उससे बाहर हो जाएगा।
सर एक बेटर स्टेप है, एक बेटर चीज़ है, वो ये है कि अगर आपका ट्रेडमार्क रजिस्टर हो जाता है तो इंटेंशन मैटर ही नहीं करती। किसी ने उसी कैटेगरी या रिलेटेड कैटेगरी के प्रोडक्ट के लिए आपका ट्रेडमार्क यूज कर लिया, वो आपको जानता भी नहीं है, तो इंटेंशन की बात ही नहीं आती, तभी भी वो लायबल है। सिर्फ रजिस्टर्ड ट्रेडमार्क्स के लिए वो तभी भी लायबल है।
थैंक यू
थैंक यू सर।
तो मानिए एक पर्टिकुलर क्लास है, उसमें आपने रजिस्ट्रेशन कराया, 10 साल तक कंटिन्यू की, रिन्यू भी कर लिया, फिर उसके बाद वो बिजनेस और वो प्रोडक्ट नहीं आगे बढ़ता, तो क्या आप 5 साल बाद फिर उसको कंटिन्यू कर सकते हैं? Get some safety precautions.
So the period is 5 years, continuous period of 5 years and 3 months. अगर उसमें आपका नॉन यूज होता है 5 years 3 months में, फिर कोई टेक्निकली चैलेंज कर सकता है आपकी कंटिन्यूटी। हाँ, लेकिन आपने 4 साल मान लीजिए नहीं किया, आपने फिर पिकअप कर दिया ब्रांड, तो आपकी प्रीवियस गुडविल और नई वाली जो है वो टाई अप हो जाती है। 5 साल का पीरियड है।
अगर 5 साल हो गया है तो उसको क्या फ्रेश अप्लाई करना पड़ेगा या उसी के कंटिन्यू?
जनरली क्या होता है, कैलकुलेट कैसे होता है कि 3 months का क्या पीरियड, बड़ा अजीब आपको लग रहा होगा, 5 years and 3 months क्यों दिया है? 3 months लॉ ने ये दिया है कि जो कैंसिलेशन के लिए अप्लाई करेगा, जिसको प्रॉब्लम है आपके मार्क्स से, वो जब अप्लाई करेगा कैंसिलेशन की पिटिशन डालेगा, उसके पहले 3 महीने और 5 साल के अंदर अगर आपका ब्रांड नहीं यूज हुआ है तो आपका कैंसिल हो जाएगा। तो हो सकता है कि 6 years हो गए बट किसी ने आपका कैंसिल नहीं किया, आपने 6th year पे करना शुरू कर दिया, 4 months हो गए, किसी ने 4 months या 5 months बाद जाकर बोला कि इन्होंने तो 6 साल पहले छोड़ दिया था, मतलब 6 साल से छोड़ दिया था, अभी 4 महीने पहले किया, तो you will still be allowed to continue that trial because from the moment somebody brings a cancellation action, immediately preceding continuous period should be 3 months and 5 years.
And one thing more, that
जी।
we have to give the extension fees or a new application?
Like extension only.
Extension.
Simple extension fees, which is the same as
So
new
the
application.
gestation period which was there for 5 years or 6 years,
जी।
on that time period we don't have to pay?
Nothing. 10 years का renewal cycle है, and that 5-year period can be any time.
First we have to go for the search.
Yes. Ideally research and then adopt, and before you launch, apply for registration. Immediately you file an application, you can start trading, and then you can continue pursuing registration. जी।
And one thing some more,
हाँ जी।
that word, slogan and trademark can be in one application
No,
and one
separate. हाँ जी, each is a different category to a separate application.
Thank you.
So I have 3 questions.
Please.
Actually, for a cookware product which I'm about to launch in February, I did some market survey and I needed a product and gave it to my designer and he designed it. Now I'm thinking to secure it. So what can I do?
So the best category of right for footwear product would be design, as we saw.
Cookware product.
Cookware. So your cookware would be design. So you could apply for registration on 2-3 different aspects. If the shape of the cookware is not traditional, if it doesn't look like a traditional handi, let's look at a crusade kind of situation, where the shape of the vessel or the cookware, if you're dealing in vessels for instance, is unique. दूर से देखा पहचान लिया कि ये इस ब्रांड का है. So if that is your case, then you should apply for registration as a shape as well. But if the shape is generic, then there must be something worthy of protecting is a design. Maybe some pattern or some shape or some ornamentation that you saw, which is applied to the article. Then you can apply for design registration of that pattern, shape, ornament as applied to the cookware article, which will be unique and very
It will
displayed.
go in copyright or it will go
In design,
patent?
design.
Okay, design. The second question is, I have a trademark which is under my closed firm. Can I renew it in my current firm?
I mean, if the firm is closed,
The author is a Kata of the old firm. Yes, yes.
okay, so if it's an HUF, it becomes a bit complex because as far as trademark law is concerned, the answer is that if an entity or a body or a company or an HUF ceases to be, then a trademark dies because it's an intangible asset. तो आप बचा नहीं सकते ना. आप ऐसे नहीं कर सकते कि पार्टनरशिप फर्म आज लीगली वाइंड अप हो गई, now it ceases to be. बट कुर्सी तो पड़ी है, मुझे दिख रही गाड़ी खड़ी है उसके नाम पर, तो वो बिकेगी तो proceeds will go to the partners. With all intangible property, including trademark, what happens is that it dies. So you have to transfer whatever you have to transfer, assign out of that entity or firm or HUF before that HUF ceases to be in existence. अब बंद पड़िए का अर्थ HUF में क्या हुआ? HUF तो कभी बंद हो ही नहीं सकती unless you decide to start a new HUF or members of the family start a new HUF and say we are officially closing the earlier HUF. Now it's no longer a unit of a Hindu undivided family. Now there are two separate Hindu undivided families that are rising out of two sons, and what the father was doing is no longer an HUF. We are surrendering the pan also and everything is done. अगर वो नहीं हुआ, is merely non-functional or whatever it is, then there is no problem. You can still claim that trademark, and if it's registered, then you can have it transferred, subject to how an HUF functions.
I'm planning for another trademark under class 7.
Right.
That trademark has been abandoned.
Right.
It was registered in the year 1970.
By you or somebody?
By someone else.
By someone else. So that is safe enough to presume.
Okay.
Engage a counsel, officially search and see. Also see the market in general. Exercise your market general due diligence to see if somebody is using that brand, not just that party or somebody else. If there is nobody and if the status of that brand is abandoned and they are also
Actually,
not
it's in use in the market.
it is, if it's in use in the market, then you know what we examined, what we discussed, that mark, the rights to trademark come out of registration as well as use. So if it's not registered or if it was registered, then it is abandoned, but it continues to be in use, they still have rights. They can apply again. So if it's in use, then you should not use that for sure.
Sir, it is better to have it in individual name.
Just a second. I think we have to close this, and CG is here with us. Once we close it, you can discuss it with him.
Yes.
Nadkar sir would like to add some. Sir, can we have a final comment from you before we close?
तीन सवाल है टिपिकल है लेट्स से हाउ कम डिजाइनर प्लेस एन ऑर्डर ऑन समबडी द माइक सर जिसको ऑर्डर प्लेस किया उसने वो माल बना लिया
जी
डिजाइनर उसकी पेमेंट नहीं कर पाया
जी
लेकिन वो वहाँ से उड़ के यहाँ पे आता है हमारे पास कि साहब हमारे डिजाइन कॉपी करके लगा दिया
जी.
तो व्हाट एप्रिसिएशन टू डू
So sir, EPCH as a body only has to encourage and basically impart knowledge or build capacity. That is what EPCH will do. EPCH as a body has no locus. केस तो फाइल नहीं कर सकते जिसका राइट हुआ है. In such cross-border cases, especially when we are dealing with regions or countries जहाँ से particularly concern है या challenge है, as regards in regularly complaint आती है कि उस region में IP rights की कोई respect नहीं है. So the correct way is that if an Indian party is sharing their design, unique proprietary design with a manufacturer in such a region, for instance Hong Kong or say mainland China, तो उनको इंश्योर करना चाहिए कि mainland China में जो copyright या design protection का law है उसमें वो पहले एक lawyer को लेकर या जिस whichever तरीके से ये पेरिस कन्वेंशन में अगर चाइना मेंबर है तो पेरिस कन्वेंशन के जरिए अपना डिज़ाइन अप्लाई करें. Protect their design and only then approach a party and disclose their design, and while disclosing their design also disclose By the way, the design that I am giving you to manufacture is protected under Chinese law, so that they get a hint that they should not try to copy it or act funny. That is what is required, because which is why I thought it was important to discuss कि ये ट्रेडमार्क और डिज़ाइन और सारा कुछ बहुत टेरिटोरियल राइट है. इंडिया में मेरा राइट है, मैंने अब ईमेल से दे दिया, चला तो 1 सेकंड में गया ईमेल से, लेकिन दूसरी कंट्री में उसकी कोई प्रोटेक्शन नहीं है मेरे पास. Now the moment I disclose it to somebody outside India, they can do whatever they want with it. Unfortunately.
एक बात दूसरी बात
जी
मान लीजिए कस्टमर ने ऑर्डर दिया यहाँ हमारे एक्सपोर्टर को,
जी
अब उस प्रोडक्ट में कस्टमर ने अपना लोगो लगवा लिया,
जी
एडवांस भेज दिया, प्रोडक्शन हो गया,
जी
बैलेंस पैसा वो नहीं दे पा रहा.
जी
अब वो कस्टमर यहाँ एक्सपोर्टर को परेशान ये कर रहा है
जी
कि मेरे को आधे दाम में दे दे, नहीं तो तू हिंदुस्तान में माल नहीं बेच सकता.
अच्छा
अब
जी
वो एक्सपोर्टर बेचारा करेगा, उसके पैसे फंसे को तो बेचेगा.
जी.
तो उसमें कोई चैलेंज है अगर वो यहाँ बेचता है तो?
सर ये बड़ा क्वेश्चनेबल चीज़ है बहुत. इसमें इशू क्या है कि अगर
कोई
किसी
कॉन्ट्रैक्ट साइन नहीं हुआ है.
हाँ वो वही प्रॉब्लम है सर. अगर कॉन्ट्रैक्ट साइन नहीं हुआ है तो बहुत प्रॉब्लम है, क्योंकि हर चीज़ जनरली टू द एक्सटेंट पॉसिबल, अगर कॉन्ट्रैक्ट फॉर्म में पॉसिबल ना हो हर टाइम, तो कम से कम हमें अपनी टर्म्स जो है वो स्टैंडर्ड इंग्लिश में बुलेट पॉइंट्स में एक ईमेल के ऊपर एग्री कर लेनी चाहिए कि ये 10 कंडीशन है. यू विल मेक द पेमेंट on this advance, I will manufacture, but if you don't make the remaining 50%, I will be entitled to sell that product regardless of what condition it is in, regardless of whether it bears any of your copyright or any of your trademark or not, and you will have no objection. Plus, I will have the right to take action against you in Indian court. ये 10 चीज़ें हमको कॉन्ट्रैक्ट फॉर्म में आइडियली, इफ नॉट एट द वेरी लीस्ट, हमको ईमेल में लिख लेनी चाहिए.
ठीक है
जी.
अच्छा, और एक थर्ड क्वेश्चन है.
जी
मान लीजिए कि आपने एक कस्टमर ने एक ब्रांड अमेरिका में रजिस्टर किया.
जी
यू एज ए प्रोड्यूसर हैज प्रोड्यूस्ड एवरीथिंग फॉर द ब्रांड.
जी.
अब वो कंपनी बिक जाती है. अब वो कंपनी उस ब्रांड को परस्यू करने में इंटरेस्टेड नहीं है.
जी.
लेकिन यहाँ जो एक्सपोर्टर है उसके पास में सब्सटेंशियल अमाउंट का माल पड़ा है.
जी.
जो ब्रांड मैनेजर है वो भी रिजाइन करके कंपनी से चला जाता है.
जी.
एक्सपोर्टर वहाँ उसको पूछता है कि भाई मैं क्या करूँ. वो कंपनी का मैनेजमेंट उसको एक लाइन की मेल भेज देता है, भाई कि हम आपसे माल एक पेमेंट देने की पोजीशन में नहीं है, वी हैव डिसकंटिन्यूड. अब वो जो ब्रांड का माल पैकेज यहाँ पे रेडी है,
जी.
कैन दैट जेंटलमैन सेल टू एनीबडी एनीवेयर or in India at least?
Sir, again, you would probably be violating that company's rights, or they will have the possibility of challenging it. उसमें भी ये सर कि agreement करना हम भी कहते हैं ज़रूरी है. तो कुछ standard clause होते हैं. ये situations हर agreement में सोची जाती है, क्योंकि हर इंडस्ट्री को अप्लाई करती है. क्लॉज होता है टर्मिनेशन में कि अगर आप इंसॉल्वेंसी प्रोसीडिंग्स में चले गए, अगर आपने अपना बिजनेस का मैनेजमेंट या इफेक्टिव कंट्रोल चेंज कर दिया. इफेक्टिव कंट्रोल की डेफिनेशन है 51% से ज़्यादा इक्विटी, मोर देन 50% ऑफ द डायरेक्टर्स ऑफ द बोर्ड चेंज इन अ नॉन रूटीन फैशन, ऐसे डिफाइन कर देते हैं हम लोग. अगर इसमें से कोई भी इवेंट ट्रिगर हुआ तो XYZ होगा. यानी भाई जैसे हमने ईमेल की बात की कि फिर मैं आपको एक चांस दूंगा, अगर आप माल को उठा लेंगे तो ठीक है, नहीं तो आई विल बी एंटाइटल्ड टू सेल इट. तो आप कहीं पे राइटिंग में उनसे लेंगे तो तभी आप कर
असल में
सकते
सब तो नई नई चीजें है ना.
जी.
अभी तक तो कोई थी नहीं, तभी तो ट्रेड के पास में नई नई ये सब प्रॉब्लम्स आ
रही है. जी.
तो आप जो बता रहे हैं उसका मतलब ये है कि उस टाइप का ड्राफ्ट बना करके वी हैव टू पुट आउट टू द इंडस्ट्री कि भाई वेरी टू द सिचुएशन you must have these clauses in your contract.
Definitely. So what EPCH could do is invest in making some templates which can be used as a standard template, और उसको फिर वो modify कर सकते हैं every member अपने हिसाब से और दे सकते हैं. That could be done.
If not in contract, then in email, as you said.
Yes.
Last
That is all idea. हाँ जी.
बहुत सारे मेंबर अपना ट्रेडमार्क रजिस्टर कराना चाहते हैं,
जी.
डिजाइन रजिस्टर कराना चाहते हैं, लेकिन वो सब परेशान रहते हैं कि जाए किसके पास.
जी.
अब जैसे इंडियन एसोसिएशन ऑफ वेल्डर्स ने एक स्टैंडर्ड चार्ट बना रखा है,
जी.
वो चार्ट सर्कुलेट हो जाता है तो किसी को भी डिसीजन लेने में आराम है कि मिनिमम मेरा इतना पैसा लगेगा
जी
इसके बाद डिपेंडिंग अपॉन एडवोकेट जिसके पास जाता हो सकता है कुछ पैसे बेसी लगे। तो ऐसा भी कोई सिस्टम आपके यहाँ पे है क्या कि एक बेसिक गाइडलाइन लोगों को मिल जाए, भाई ये करोगे तो इतने खर्च का बजट बना के करना पड़ेगा?
जी सर, मैं एक बॉल पार्क आइडिया दे सकता हूँ, बट हमारे यहाँ कोई एसोसिएशन रेट्स इसलिए नहीं फिक्स करती क्योंकि हमारे कंपटीशन लॉ का एंगल, एक तो बार काउंसिल में प्रॉब्लम है, वो प्रिवेंट करती है, हमारा लाइसेंस प्रोविजन है कि हम लोग एक एसोसिएशन बना के रेट्स फिक्स करें, बिकॉज देन दैट मेक्स इट पोटेंशियली एंटी कम्पिटिटिव कि 20 लोग मिले और उन्होंने राइटिंग में एक एसोसिएशन के थ्रू रेट फिक्स कर दी। अब गिव इट और टेक इट है, और जो मेंबर्स हैं उनकी भी मेंबरशिप रूल्स ये होते हैं कि सो लॉन्ग एज यू आर अ मेंबर यू हैव टू अबाइड बाय व्हाट द मेजॉरिटी डिसाइड्स एंड सो ऑन। तो इसलिए रेट्स हमारी इंडस्ट्री में फिक्स
लेकिन एक रफ गाइडलाइन हमें आप दे सकते हैं?
हाँ हाँ बिल्कुल सर, वो तो हमेशा
जरा गाइड कर दो थोड़ा अच्छा रहेगा।
बिल्कुल जी,
सो दैट पीपल कैन मेक बजट एंड पीपल जंप ऑन।
जी जी
अदरवाइज बहुत इसी चिंता में
जी
Sir, I think we have to close it now.
जी
And one more thing before we close. I mean, you spoke about EPCL Design Register Initiative. If any one of you wants to know more about Design Register, our designer Mr. Sunil is here. Sunil, अपना email ID बता दो.
It's sunil@epch.com.
If anyone wants to know anything about Design Register, please contact Mr. Sunil.
Chaliye, I think with that we
yes yes of course.
Let's wind up now. I request Prahlad ji to present a memento to Ankit ji for very effectively enumerating on all the factors related to IP. It was a very knowledgeable session.
because people could understand.
This is a memento on behalf of EPC.
उधर आ जाते हैं तैयार हो जाए देख ले।
Thanks to all once again.
आप हम लोगों से जुड़े रहो क्योंकि हमारे स्टेट की बहुत सारी प्रॉब्लम्स हैं, सो वी नीड पीपल लाइक दैट हु अंडरस्टैंड्स और वो काम आगे बढ़ सकते
ये जो सर 25 साल से हमारे साथ जुड़े हैं, उनके साथ आपकी तरह हमारे साथ जुड़े हैं।
ठीक है। मैं अपना थॉट देता हूँ।
जी